Good afternoon, everyone, and welcome to the 8th talk in the Only One Theme series, which is focused around innovation management. Today's topic is freedom to operate, and our speaker for today is Dr. Sivakami Dhulap. Let me briefly introduce Sivakami. Sivakami is principal scientist at CSIR URDIP. She holds a PhD in information sciences with a focus on non-obviousness criteria required for patentability. She has also completed a postgraduate diploma in patents law from NALSAR University of Law, Hyderabad, and a postgraduate diploma in Cheminformatics from Jamia Hamdard University. She has more than 20 years of experience in providing patent analytics and technology commercial information services to clients in public and private sectors, primarily in chemicals, pharmaceuticals, and process industry. Her expertise also lies in building subject-specific databases, and she has experience in incorporating cheminformatics tools to assist the ongoing drug discovery programs. Sivakami has been recipient of the Society for Information Sciences Young Information Scientist Award and the Innovation Challenge Award. She has published more than 10 papers related to patent analytics as well as cheminformatics topics and presented in around 8 conference presentations. With this brief introduction, welcome Sivakami to the session, and over to you.
Good afternoon, everybody, and thank you, Dr. Hamdard. And also, I would like to thank Director of Venture Center and their team for giving me an opportunity to share my learnings on the topics such as freedom to operate analysis. So, without taking much time, I would like to go ahead with the presentation. If you have any questions, please feel free to stop me, and we can always interact in between. So what I will do is I'll just spend few minutes and take you through the basics of intellectual property right, only those aspects which we really need to understand in order to conduct an FTO analysis. Then I'll also continue. Yeah. And then I will go into the details of freedom to operate analysis, where I will take you through right from the definition, how do we actually have to conduct a freedom to operate analysis, wherein the steps will involve searching for the patents, analyzing the patents, understanding the technical details of the invention, and comparing it to the product which you want, for which we are conducting the freedom to operate analysis. Then I will also go into the details of after we do the search analysis, then we will try to summarize the data and provide an opinion for the freedom to operate. I'll take in just 2 case studies to illustrate how important is a freedom to operate analysis before you launch a product, and then try to summarize my presentation. So I think everybody, we have frequently come across the boards like this, which mentions no trespassing or trespassers are not allowed, mainly in private lands or houses. So which indicates that you are not allowed to enter in someone else's private property or land unless without taking permission from them. So if you enter it without taking permission from them, of course, it will be a punishable offense. So on similar lines, I would, in today's session, I will tell you, or I will discuss on what causes infringement of IP and more specifically on patents, and how does an FTO analysis help you in avoiding any legal risk or infringement risk. So we all, at least this group or this audience, will be aware of intellectual property, but I will just take few minutes to explain it. So intellectual property, as a definition, it refers to creations of mind. It could be an invention. It could be literary and artistic works, designs, symbols, images, and so on. And like we have our private land or houses, they are usually called as tangible property. But these kind of intellectual property, they are called as intangible assets, and they are protected by law. They can be owned by an individual person, a group of people together who can be a startup company or big companies. There are different forms of intellectual property, which mainly the inventions are protected by patents. Then you have copyrights, you have the symbols and the designs which are protected by trademarks. Then you have industrial designs, geographical indications, and trade secrets. In today's presentation, we will focus more on the infringement for patents and FTO as a remedy to avoid any legal risk. So going into, like we have seen, trespassing private property, let us see what constitutes an infringement for intellectual property rights. So if you manufacture, sell, use, import, copy any product or process which are protected by patents, then that act will cause an infringement. And that also if you're using it without the permission of the IP owner. So if you use it without the permission of the IP owner, the IP owner has every right to take a legal action against you, and in some certain cases, he may also claim damages. So that is why freedom to operate analysis is very important, which you have to conduct as a study in order to make sure that a particular action, which could be testing or commercializing a product, that we have to confirm or determine that it will not infringe or read upon any valid intellectual property rights, and more particularly, it should not read upon any valid patents. Okay, that is what we actually check in a freedom to operate analysis. This freedom to operate analysis is usually also called as freedom to practice. It is also called as an IP due diligence study, a risk assessment study, or a IP clearance analysis, because finally what you are getting is, you are getting an opinion that you have a clearance to launch or manufacture your product. So that is why it is also called as an IP clearance analysis. So what I will be focusing on is what is the purpose of the study, when one has to carry out an FTO analysis, what is the methodology we usually adopt and one can adopt in order to carry out the FTO analysis, right from the searching, what databases you have to use, what analysis you have to do by reading the patents, what should be the focus. For example, in an FTO analysis, claims should be the most important part in your analysis. And then I'll take you through how, after we do all the process, how do we summarize the data in order to provide an opinion. So the purpose, we really have to understand what is the purpose of carrying out an FTO analysis. So the purpose is, if you want to launch your product, or before entering into a licensing agreement with a third-party company, you need to see whether you are not entering into, you will not have any possible legal risk. So that is the main purpose of conducting an FTO analysis. And of course, to avoid any kind of infringement, legal risk, specifically with respect to patents or any other intellectual property rights which are protecting a given product or a process, or it could also be a device or apparatus. In many of the cases, all we know that most of the inventions which are being made as on today, they are improvement on the existing products or process. So routinely, the inventors are trying to improve on the existing process so that their function or the yield can be improved. Or it could be coming up with identifying new use of the known materials or drugs. So when we have these kind of incremental innovations or technologies, it is also necessary that we conduct an FTO analysis at the beginning itself, so that the product or process which you are trying to improve upon, we make sure that we can find what are those patents protecting the already existing products, so that you can read those patents and try to design around it. So if you conduct an FTO analysis for a product or a process or a device apparatus which is already existing, then you are from the start of the R&D, you are making sure that you are developing a non-infringing process or a product. So that is why in many of the cases, in some R&D people, they try to do an FTO analysis in the beginning also. But more accurately, an FTO analysis is usually done when you are ready with a prototype, or what we call as the pilot scale process. It could be a prototype of the product. You are ready to launch with the product, or you are ready to have a licensing agreement with a third party, and you want to license your technology. So in these terms, FTO analysis can be done depending on the technology readiness, which nowadays is called as the TRL levels. So depending on those levels, an FTO analysis can be done. So these two slides, it explains that what should be the purpose and when actually an FTO analysis should be carried out. Then going to the methodology, once I get a request for conducting an FTO analysis, it could be a product, as I told you, product in terms of pharmaceutical compositions. It could be a tablet comprising an active ingredient used maybe for antiviral use, or against tuberculosis or against cancer. Or it could be a very simple cosmetic formulation. It could be a dietary supplement. So you have different kinds of compositions. It could be an agrochemical product. So all these products are having multiple components. Okay. So when you have to do a FTO analysis for such kind of complex products, which itself has multiple technologies or a device, you have to understand the technology or the product and its features. You need to understand that so that you can develop your search strategy to carry out a search on different databases. So we usually use a combination of different keywords and what are also called as patent classification codes. We also look into the citations of the patents which we have already retrieved. So that helps us in giving an idea of what are the related patents in that technological area. Then, of course, we also have to look into the subject-specific requirements. For example, if today I'm doing a chemical, a product which is having some chemical compounds, so it is important for me to understand what is the structure or what is the molecular formula defining that chemical compound. So once I understand the details of the structure, I can do a structure search. And I will not go too much into details of the searching, but basically we need to understand that if it is a chemical compound, we have to make sure that apart from the keywords or classification codes, you also have to do a structure search. You will end up in getting better results. So that is a very subject-specific quality for chemicals or what we call as pharmaceuticals, depending upon the application area. And if it is engineering inventions, you have to look into the diagrams, because the diagrams or the arrangement of the components, they are very much essential for you to understand what is the product and compare it with the prior art.
So, Sivakami, there is one question for you at this point. You mentioned that FTO should be done, say, at the prototype stage or at pilot stage.
Yeah.
Shri wants to understand, should it not be done before that, so that it is possible to know the new or novelty parts, or what is done at our end or what is not possible?
Yeah. So novelty part is what you access or what you evaluate for a patentability criteria. But for freedom to operate, yes, you can do it, provided you know that you are improving upon something. So if you are improving upon something, it is always better to see that that kind of materials which you are using as a starting material, or it could be a catalyst, or it could be a component which is already patent protected, then it is always better to do an FTO to find out what are the product patents or what are the live and enforceable patents which are already there, which you are using in your product or a process. So that will always help to make a checklist of these are the patents which are patent protected. It's a catalyst. Am I using this catalyst which is already patent protected? So yes, it is always better to do it even at the starting.
And you will be touching upon the different databases, right?
Yes, I will be touching upon the different databases which are important to be used for a freedom to operate analysis. So as I said, the subject knowledge about the invention or the product which you are doing is important. So that will decide on how you can go about doing the searches. So likewise, you have to look into the figures and arrangement of each of the component and its function for engineering field. And if it is biologics, of course, you have to look into what is the gene sequence, is it patent protected, amino acids, peptides. So depending upon the subject specificity of your product or the process, we usually define the search strategy. So when you do a FTO analysis, it is required that you should have the complete information of the product for which you want to do the FTO analysis. If you have half away information, that will not give you a complete. For example, somebody will tell me that you want to do a process. He will give me the information about the first step, which is conversion of A to B using catalyst C. Okay, but if suppose I don't have the process parameters, or I don't know what catalyst is used, is it a chemical based catalyst? Is it a mixed oxide catalyst? Is it a bio catalyst like an enzyme? So if I don't know what is the catalyst and I'm just looking blankly at A to B conversion, then I'm literally missing on the patents which are protected only for the catalyst. So I will be missing on really giving an opinion for the whole process. So halfway information, as we all know, not only in IP but in any technical field of research, it will have a risk. So it's always important to first interact as much as possible with the inventors or with the party who is planning to get the FTO analysis done, so that we understand the full features of the product and in what way they want to launch. If it is, for example, a pharmaceutical form, it could be a tablet form, it could be a capsule form, it could be a liquid. Nowadays, you also have a altogether different formulation for pediatric patients, for children. So even though the active remains the same, even if the form is different, means the final formulation is different. So that is why we need to understand the technical details of the final product in order to do the FTO analysis. So the first thing for you as an IP analyst, or for me, whoever is conducting the IP of the FTO analysis, it is important for us to ask the client few questions. So let me discuss on what are these questions. First one is you need to ask what is the product for which you want to conduct an FTO analysis. So whether the product, it could, like I've told it, from different technical fields, it could be a composition, it could be a formulation, it could be just a chemical compound, which is an active ingredient, which you are planning to use it in different applications. Okay, so it could be just a catalyst, a process, device. So you need to understand every feature of the product, even if you're using an excipient in the formulation, or even if you're using the reactant, you need to understand what is the nature of the reactant and how is it performing. So all these technical information of the product and its features, it helps the analyst to design the search strategy properly so that I can collect the relevant information. It's not that I should begin with the patent search directly. It's always better that we read some scientific literature articles so that we get a feel of the background of the invention. And then afterwards, if you read a patent, which is a legal document, the claims are very much different as compared to the scientific literature. So that reading background, it will always help. So defining the product in detail with respect to its features as well as its function, it helps the searcher to perform a better search, to generate keywords, identify the relevant classification codes, and then to build the search strategy. The next question you have to ask your client is where are you planning to launch your product? Because we know that patent is a territorial right. So if the client is planning to launch the product only in India or US, because the market could be over there. So if you know beforehand that you are planning to launch your product in these countries, it would be better to just do the search or restrict the search to these jurisdictions, at least to avoid, to minimize the time. And of course, if you are getting a FTO analysis done from a legal entity or a law firm, your charges also will be more. So it is always better to ask this so that you can refine your search. First, give an opinion for those areas where they want to launch the product, and then you can extend. If suppose they want to extend their market to some other countries, we can do that also. So the time also is important. Sometimes you will do an FTO analysis today, but if the product is going to be ready after 2 or 3 years, then that FTO report will not be valid. Why? Because you see every year, as in today's publication, I have read that US around 3 lakh patents are granted in a day, in a year, in the United States. So every day, some new applications are being published, new patents are being granted. So to ensure that when you're doing the FTO analysis, you don't miss on any relevant records or patents, it's always necessary to understand when to conduct. Suppose you do the freedom to operate analysis today, but your products, due to some technical delay, it will be launched in a year or 2. It's always better to update the FTO analysis and give it to your client. So knowing the answer to when your client is going to launch the product is also very much important. And that also helps us as an IP analyst. It also helps us in refining the search, restricting the search to the required geographical markets where the product is planning to be launched. So all that will help to refine our search and do a detailed analysis. So once all this background and questions are relevant, we do the search. We analyze, we shortlist only the most potentially relevant patents with respect to the technical features of the product and try to make a list. Once suppose it could be like out of 50, you have refined the records and you have 10 to 15 most relevant patents covering most of the features of the products. Then I have to read those patents and specifically the claims in detail to again answer a few more questions. So here we need to understand that do the claims appear to cover all the features of the product? Is the product and the features found in a granted and enforceable patent? So if it is application, for the time being, you can keep it aside. But if it's a granted patent, you literally critically have to look into the claims to understand that. And then you also have to see what is the legal status of the patent. Is it completed the patent term? It is expired, and all these issues. So at this moment, you are just analyzing the technical details of the patents, trying to map the features of your product with the claims and make a list of all the required documents. Then with respect to the technical details, usually in an FTO analysis, you have to focus on the independent claims of the patent. But of course, you can't leave off the dependent claims. You also have to look into that. Again, as I've told you, as far as it is chemistry, you have to look. We have something called as a Markush claims, which are protected by big pharma companies, where each of the claim, actually protects thousands of molecules. So we have to literally look into the broad generic structure which is claimed and try to see what are the R groups, try to enumerate them and see whether your structure or your chemical or your catalyst is encompassed within the scope of the claim. That is what you have to actually see while analyzing the patent documents. And when for biological things, you have to look into whether the exact sequence is within the claim or not. And of course, for engineering applications or devices, you will have to see whether the claim is covering all the features of your product. So based on the detailed analysis of the claims and reading the specification, we make a map where we try to map all the features of the product to the claim that we have identified that this is the most relevant part of the patent. So apart from the technical details, we also look into other bibliographic information for that potentially relevant list. It could be 5 or it could be 10. The list will of course not be so long because you have spent time in refining the search, reading the patents and coming to this list, this short list. So after looking into all the technical features, comparing it with your product, you need to see who is the company, who is the assignee, what are the dates. The dates are important because you need to know what is the filing date, what is the grant date, then what are the claims, what are the other countries, what is generally called as family members. So you have a patent in US, but the same patent could be protected in 10 different countries. So you have to separately make a list of all the other geographical nations where the same patent has been protected. You have to make a list of what is the legal status. Sometimes the patent could be valid for another 3 or 4 years. But if the company, due to some reasons, if they might have not paid the maintenance fee, then you can say that the patent is lapsed. So it is important to look into the legal status of each of the patent which you have shortlisted and just gather all this information apart from the technical details. Because we know that from the filing date, the patent term is 20 years from the filing date. So you can also approximately calculate and keep it. So all this is we are making the technical data and the non-technical data ready for further analysis for the FT. So we usually do collect all this information, technical and non-technical, in the form of a spreadsheet, where for one patent, we tag all the features as well as the non-technical information in the form of Excel sheet, so that all the information is available at a single point. So now you have finished the search, you have finished the analysis, you have compiled with all the other legal data with respect to the patent, who is the company, the dates, the legal status, and so on. So then we have to see what would be the risk associated with the freedom to operate. So there are two options. If all the features of your product, if your product is covered or claimed by at least one granted and enforceable patent, then you will not have a freedom to operate. So if you don't have a freedom to operate, then you are left with two options. Either you have to wait until the patent expires, or you have to license, collaborate, or purchase that technology from the company which you have identified who is the owner of that patent. Of course, there are some exemptions to experimental use. You can prove that if you are doing it for experimental use, there are some exemptions. You have to fill the required forms. So I'll not go into the section part for now. But of course, if you have from the analysis, if you have figured out that your product or a process is not covered by any granted or enforceable patent in the geographies where you are planning to launch your product, then of course we say that the patent is either not there or the patent is in public domain, and that is why you will have a freedom to operate. So these are the only two options which you have if you have identified that there is a granted patent or there is no patent covering such product at all. So this is just the theory part. So what I'll do is quickly take you through two case studies, which will give you a better clarification of what we have discussed so far. As you all see, this is an invention, which is a light bulb which was made long back. So I would just like to ask one question. What comes to your mind as an inventor for this light bulb? You can write the answers. I'll just give you 2 seconds. So if there are...
Write your answers in the chat box. We can just repeat the question.
Who has invented the light bulb? So any names that just come in front of your mind?
Thomas Alva Edison.
Thomas Edison. Okay. Usually we get this answer, but let me tell you this is wrong, because we know Thomas Edison as the person who has commercialized the product, but the actual inventor for the light bulb was Henry Woodward, and he had even a patent protection for the light bulb, which was invented first by him. So he had the light bulb, which was comprising of the carbon filament, a suitable vessel, what we today call as the lamp, and a rarefied gas. So this all together is a final product, and it was actually first invented by Henry Woodward, for which he had filed a patent in Canada and US, and he had a granted patent for both this. What did Thomas Edison do is he actually worked on the filament, which we know that the filament which was first invented was not of practical use. So in order to make the bulb to be practically useful and be commercialized in the market, Thomas Edison worked on the filament, and he was successful in improving it so that we all could use it, or it could be commercialized in the market. And that is why, because there already was a claim of protecting the light bulb comprising of these 3 elements, Thomas Edison had to take an exclusive license from Henry Woodward and then improve upon it to actually bring it into the market. So this is the way where FTO actually comes into picture, where you have to make sure that the elements which you are using in your product should not already be patent protected. And of course, then after Edison, many more improvements came on and the patents were protected, but all that was an improvement patents. Okay. So now typically we'll apply the same analogy when we are doing an FTO analysis for a complex products, like it could be a pharmaceutical invention. So whether it is a pharmaceutical invention or you take cosmetics, which we use day in and out in our everyday life, it could be an agrochemical like a fertilizer, a pesticide. Okay, so all these inventions, they will comprise of an active ingredient which is responsible for the primary activity. And this active ingredient is usually defined by a chemical structure. So if you can see on my slide, this chemical structure which you can see is called as the active ingredient, and which is well protected by a patent. So here I have taken example of an anti-diabetic drug, sitagliptins. You have the gliptin family, and this is one of them. So the active ingredient basically is protected by a patent, what we call as the product patent. Then this active ingredient has to be going into a formulation, which you can see it can be a tablet format, which is 50, which is available in 50 mg, 850 mg. So the formulation will become different depending upon the dosage or for whom it is given. If it has to be given to patients having hypertension, nowadays you also have this ingredient combined with a second therapeutic active. Okay, so depending upon the formulation chemistry is totally different. So the formulation can also be protected by patents. And of course, nowadays you have the salt forms or the enantiomers, which are protected in some of the countries where they are allowed. So if you take a typical pharmaceutical, agrochemical, cosmeceutical product, it will have a chemical compound, it will have a formulation, and it will have a form, what we call as a tablet form or a capsule or an injection form. Okay, so this all together defines one single product. Now, if suppose somebody, assignee comes to me and they have used the same active ingredient, okay, which is an anti-diabetic compound, but he has made a new formulation. And this is the details of the formulation which he has given to me. That is, he's having a molecule which is an anti-diabetic effect. He's including a second therapeutic active, which is what we call as a combination therapy. And of course, because you have to make a formulation, you also have to have other ingredients like a carrier or what we call as excipients in formulations. So if this is the technical details given to me to conduct an FTO analysis, let us see how do we have to go ahead. Now, in this case, the client who had come, he also had this formulation protected by a patent. We need to understand that patents and FTO, these are two different aspects. You may have a granted patent, but that does not ensure that you will have a freedom to operate. Even if you have a granted patent, you will have to, when you practice that invention or you are licensing it to somebody, you have to conduct an FTO analysis to see whether each of this feature is independently protected in a different patent, or the formulation altogether, whether it is being already protected by somebody else. So these are the things which you have to check. So let us see if a client has come to me with this formulation, anti-diabetic formulation, how will I go about it? So here the client has come to me with this formulation and he's already having a patent, granted patent. He wants to manufacture and he wants to license it to a manufacturer who in turn wants to manufacture this on a larger scale and sell this product. So before entering into the licensing agreement with the manufacturing company, you have to do the FTO analysis. Many a times, like recently we had a case where we were working on polymeric membranes used in fuel cells. So in some of the cases, both the person who is giving the license and the person who is taking the license, both can do the FTO analysis. So in our case, both of us did the FTO analysis and we sat together to discuss what could be the possible risk. So the first thing, when the technical details are given to me in the form of a patent, or it could be in a written document, I will try to deconstruct the product. So in the first step, while deconstructing the product, I need to understand that this product is having one active component, which is defined by a proper chemical structure, molecular formula, molecular weight, and so on. Then the second important feature is the pharmaceutical composition. What are the ingredients that are going into the product apart from the active ingredient? It could be a solvent, it could be a carrier, it could be even a color pigment. Sometimes, you know, when specifically there are medicines for children, they wanted to have a sweeter taste so that it could be useful for the pediatric patients. So if you have to bring that effect, you need to add that component giving the sweetening effect. So that these are called as the additional pharmaceutical ingredients which will go into the product. Of course, there will be a claim, you might have made this compound or the formulation using a specific process technology. So that also I will have to see. And then of course, a method of treatment. Sometimes method of treatment, although in India it is not patent protected, but there are a couple of patents in US which allows the protection of method of treatment, where it will define what is the dosage requirement, how you have to give it, all those things are defined. So the product which is given to me for an FTO analysis will be deconstructed in this way, because each feature is a technology by itself. So once I've understood by reading the background or interacting with the inventor or the client, I've understood what are the technical details, then I will focus on the search. So while I am doing a search for this kind of inventions, I need to understand what is the chemical compound, what is the structure, how it is defined, what is the chemical class, what is the drug class, use formulations, and so on. Usually we use both free and subscribed databases. I'll touch upon it later on. Then we have to define a strategy where I will do a separate strategy for the active ingredient. Then I'll come to the formulation. Usually if it's a chemical structure, I told you it can be defined by the structure, molecular formula. There is something called as the CAS registry numbers, which are very useful for chemical, pharmaceutical inventions, because every chemical formula, as soon as it invented, gas number is being registered. So even if you are a supplier, it is an internationally accepted number. So sometimes, IUPAC names for chemicals becomes very difficult. So that time you can use the structure or the gas registry number, because it is a universally accepted thing for doing the search on different databases. And of course, then you have to use the information about other details like excipients, solvents, and so on. So coming to the patent databases, these are the freely available databases. Nowadays, all these freely available databases are, it was not the way which we used 20 years back. I'm into this field for the last 20 years, as ma'am has mentioned, but all these free databases have been very advanced right now. So you can actually try these databases, and they are useful. One is the eSpaceNet, which covers the global, all the worldwide patents. Then you have the patent database from the USPTO. These are the National Patent Office of the United States. Then for today's generation, you have something called as Google Patents, which is very user-friendly. And of course, there is an advanced search also. But like we do a Google search, you can try initiate your search by doing a Google search on the Google patents. And then you can come to eSpace and USPTO. Then there is something called as Patent Scope, which is given by the World Intellectual Property, which has all the PCT filings. So you can also track what is the PCT application, and then you can check which countries or which national phases the patent has entered, and then you can keep tracking like that. So these are some of the free databases. Each one has its own advantage, but let me tell you, each of the database has simple search where you can just, if you are not having an experience on patent searching, you can just do the simple search option. Then you have advanced search, which gives you where you can put a combination of keywords. If you already know that that this company is already having the patent, so you can, like we know, like Tata Nano is, the patents will be filed by Tata Motors. So you can search by the assignee. So when you have keywords, you can put the inventor name, you can put the assignee name. So you can do it in one go in an advanced search. Then these are some of the paid or what we call as subscribed databases which we have. That is PadPace, you have Orbit Intelligence. Then you have a couple of databases like STN and CAS. And these are very specialized tools where you can do multiple strings, you can put it together. Then you have advanced search options where you can draw the structure. This drawing of the structures are not available in free database. Nowadays, WIPO, the patent scope which I showed, of course that has it, but it is not, it is restricted only to the WIPO PCT applications. But these databases, the advantage is you have multiple countries covered in the same database, so you save a lot of time. The removing of duplicacy, that becomes easier when you use these advanced search tools. Then you have some graphical analysis. You can see the claims side by side. You can refine your search. So all these are the added advantages with the subscribed databases. So suppose knowing after deconstructing the product, understanding the features, I do the search, I build up the search query, I do the search on these databases. So after I do the search for this invention, I found that there are 10 patents, out of which I have selected 2 important patents. One is the European patent and one is the USPTO patent. So once I select that these both are covering the all the features of the product which for which I'm doing the F2 analysis, I need to ask 2 questions. Okay, so the question which I have to ask is the active ingredient which is contributing to the anti-diabetic effect, is that protected by these patents? Then the other thing is the formulation is something what is new, which the client has come to me. So is the formulation per se comprising A, B, C, and D? So this formulation comprising these 4 features, is that protected by these granted and enforceable patents? So what we do is after we find out that these are the critical patents, we try to map the features of the product to the claims. Okay. So I write, this is the prior art one, that is the US patent and the EP patent. So the first patent covers the active ingredient, which is my main active covering responsible for the anti-diabetic effect. And of course, it is not covering the carrier or the second therapeutic active. If this patent is in force, then I have to look into the legal status, which I told you. These are the non-technical parameters which you have to see. If it, in this case, this patent was still in force, then the other EP patent, which I have already shortlisted, if you can see, I've tried to map the claims with the features of the product which I am analyzing. So this EP patent covers the active ingredient. It covers the second therapeutic active, which my client is using. It is also covering the same carrier, which is used in the formulation and also for the same application. So if you see that the prior art one, the prior art patent one covers the active ingredient, which is the most critical part of my formulation. And the second part covers all the features of the product. So once I do this, this is a kind of claim mapping, which we usually do in order to tell the client that this are the independent claims, claim 1 to 11 maybe are the claims which are protecting the active ingredients. Then the carrier, so this is a formulation patent. The second active is also protect in the same patent, the salt form, carrier, and the composition for the antidote. So all the features are claimed in the same patent which I have identified. So then we have to go and see what is the legal status. If suppose my client is interested in marketing this anti-diabetic product in US and maybe India, I have to see whether this patent, the EP patent, which is covering all the features of my product, is it protected in India and US? And see, I have looked into the details of the family members. Family members is you have a patent, you can apply for the same patent in different countries. So based on the examination, what will happen? Your patent will get granted. So in this case, the prior art patent which I have identified was not only protected in Europe, but also in US, Portugal. So in all these countries which I have showed it in the map, it is being protected in these many countries. So this is also the kind of the type of data which we collect apart from the comparison of the technical features. So the proposed formulation, according to this analysis, will have a restriction on the freedom to operate, or what we call as the freedom to practice option, in the countries where the US patent is protected and the EP patent. So as you can see in the map, the US patent itself was protected in 15 countries. And in some of the countries, I just went through all the family members. In all other family, some of the family members, it was still in the application stage. So we need to really track even the applications. We need to monitor it, whether it is going to get granted until the launch of the product you have. But in this case, anyways, the client will not have a freedom to operate option because the active ingredient and all the features of the product are protected by a granted and enforceable patent. So what are the options? So when I'm giving an opinion, it is like either you have to wait till these two patents expire, at least in the countries where you want to market your launch your product. You have to wait till the expiry, or you will have to take a license only for the active ingredient and design around the formulation patent so that your formulation is completely new and non-infringing. So once you have designed around a new formulation, you have to again do a recheck on whether this EP patent or there are other any granted patents covering the features. So that is how you have to keep tracking and analyzing the patents. Okay, so in this case, of course, you legally have to wait, or you will have to invent around the identified patent which we have got. So in the case two, the case would have been a different case if suppose I did not get any prior art where all the features of these formulation are not claimed, then you will have an FTO. So to summarize, You need to understand the details of the invention. You need to understand the business plans of your client, where they want to launch, when they want to launch, okay, or whether they are giving the technology to a third party who in turn will be manufacturing and selling the product. So you need to understand the technology as an invention and also the business plans. Then you have to find the potentially relevant patent documents. It is granted patents are more important, but also you can make a list of the most recent patent applications so that you can keep a track, or you can just give it as an additional information to the client. Then the claims are the most important part, which you have to go through and read and analyze in a patent document. It will always be helpful to use specialized tools so that you are minimizing the errors. You spend less time in removing duplicates and making a clean list to generate the patents, and so that you can analyze. You need to understand, literally analyze the claim specifically. If it is a Markush claim, structure claim, amino acid claims, or a diagram with respect to engineering, you need to see all the features of the claims and then compare it to the prior art. You also have to see what is the scope of the patent, what is it covered and what is not covered. So all this information, you can list it out, and while discussing with the client or while we are writing the report, we discuss all these possibilities along, of course, by giving a freedom to operate analysis. So this is all what I have to share. Thank you for your patient listening, and I can take up questions. So this is our website, which is the URDIP website. You can just have a look at it to understand what exactly are the different kinds of analysis which we do.
Thank you, Sivakami, for covering this entire landscape. I would say it's a very difficult task to cover it in such a short time. I know, Dr. Premnath, you have a hard stop in under 5 minutes. You had any comments before you want to leave?
Thank you very much, Sivakami. I think it was very useful, especially the case studies and examples that you provided as well. So thank you very much. Just a quick question to you. Even in situations where somebody is, say, working with a know-how, which is a proprietary know-how, and let's say they have not filed a patent, they will still need to do FTO analysis for because somebody else's patent they might be infringing. So if you have such a case, how do you go about evaluating FTO in such cases? Because you'll have to entirely lay out the whole know-how to understand which part is infringing.
In such a case, specifically the smaller parameters, if we have come across when we have done processes where the exact things are technical details of the know-how are not disclosed in a patent document, but that we literally discuss with the client, and of course they have to disclose it to us with a binding non-disclosure agreement, and we maintain the confidentiality. And it's important to check, even if it is a process parameter, a range, it could be a temperature range. So there in the process, it becomes important to understand that this is the parameter at this temperature or at these conditions, the process is actually giving you the results. So that time it really, because that is what I feel will go into your pilot scale or into the manufacturing process at a larger scale. So yes, that has to be taken into account while you conduct an FTO analysis.
Yeah, thanks. I think over to other questions, please.
Yeah. So there are a few more questions in the chat box. I'll just take them one by one. I think you referred to the databases which are available for chemical structure. Yeah. So it's there on the slides also.
Yes. Yeah. There is one called as Patent Scope, which is freely available. You can you can see Patent Scope. So this is the database freely available, but this is only for PCT applications. But you can go into the national phases and check for the granted patents. This gives it will give a fair idea. The login is free. You can register for free and draw your structure, and you can just try doing the structure search. but this will be restricted only to PCT applications. It will not cover all the patents.
Right.
This is the only disadvantage of the free databases.
So in the paid ones in that,
Yes.
you mentioned few of them.
Yes, so the paid ones will give chemical searching, specifically the gas database which we have. You can do structure search, substructure search, and all those things.
Right. There's a question from Bhagyashree. She says, a chemical compound structure is known, but I want to file same compound isolation for the same compound isolation method patent. So is it possible to file?
So if your process is new, isolating or preparing, if it is isolating, I think it will be a natural product. So if it is an isolating process, I think it should be your compound will be a natural product. So you will have to check on whether your isolating process is totally new or not, and that is the patentability criteria. If you want to actually use that process, then you will have to check the FTO analysis.
Ma'am, actually, I'm working on one terpene synthase, which is anti-cancer product, and that product from another plant is already reported in literature. But that method I'm using this time is totally novel, so that's why I asked the question.
Yeah,
like,
so depending upon, you will have to do a prior art search to check whether your process is reported in any other prior art. It could be because it's a natural product, somebody might have disclosed it in the literature also.
Yes,
so
it can possibly.
Patentability, that is a patentability issue. So for patentability, if it is reported anywhere in the prior art, including a literature, then you can't protect it. But if it is not reported, the process, then you can protect it by patent. But today's session, I focused on FTO, which is you might get a patent, but afterwards, if you are licensing your process to somebody who will do it on a larger scale, you will have to conduct an FTO analysis for your process.
Yes, ma'am.
Yeah.
There's a question from Indu. If the end product is same, but the extraction method is different, how shall we judge the FTO in such a case?
End product is
same, but extraction method is different.
Yeah, so the process is different. If your end product is a natural product, then naturally there will not be any IP because natural products cannot be patent protected. But if your product is a semi-synthetic or a new derivative, then you will have to check on if it is covered by a product.
Mugdha, there's some disturbance, Mugdha. Hello? Yes, sorry, Sivakami, can you continue again the answer, please? There was some overrun between two mics. Yeah.
Okay. So I suppose what you are mentioning, if it is a natural product, then it will not be protected by a patent. And then you only have to check for your process, the freedom to operate analysis for your process. But if you are making a new derivative based on that natural product, then you also have to check if there are any other product patents covering that new derivative. So that time you have to do a FTO analysis for the process as well as the product.
Just Mugdha has put out a link to the feedback form people can fill up that helps us improve our programs as we go along. I think, Mugdha, did you have any other? I think there's
there's one more question from Somnath. Can we have claims for a different extraction process?
Yeah, you can have claims for a different process. Unless and until it's not disclosed by anybody else.
Yeah, so Sivakami's claim point was that you can, if your process is novel, you will get a claim approved for novel process.
Yes.
But if the underlying product is protected by somebody else, you still may not have FTO yet. So you might have to go and get a license from the person who has a claim on the product to make the same product with a different process.
Correct.
Right?
Yes. So that is why we say that the claims on the product are stronger than the process.
Yeah.
Yeah. Indu, we have unmuted you. You can.
Yeah, thank you, Mugdha. Yeah, actually, ma'am, my question was just imagine if there is they are extracting some.
Everyone.
Yeah, they are extracting some
Mugdha,
oil.
Mugdha, there's some sound coming up.
Venture Center and National Biopharma Mission supported.
Mugdha?
Yeah, we are just checking what is the problem.
Yeah. I think the video is playing somewhere.
Second and fourth Tuesdays between 4 to 5 p.m.
Mugdha, you can just mute everybody.
Talk about one theme at a time, and today's theme is around patent.
Okay. Yeah. Yeah, ma'am. So my question was, just imagine it's an innovation in which they are extracting some kind of an oil from a naturally occurring a seed, maybe. Okay, and that is being patented. And if a researcher comes to me saying that they are extracting some kind of a compound from the same seed maybe in a powder form, in that case, can I say that my innovation or what my research have brought in as an FTO, since the patent has been granted only for that extraction of oil from that seed? That was what my question.
So here the final product, I feel, as far as I've understood it, it is in a different form.
Exactly.
Form.
Exactly.
So the process which is yielding this different form itself, if it is different, and even the product features are different, and if it is not claimed in any granted patent, then of course you will have a freedom to operate, but you have to check it. You will have to conduct a search to see that there are no other patents on the powder form of that product.
Yeah. So there's one question from Sudhanan. If the natural product is not known, can't you file patent?
No, because many of the patent laws of different countries, natural products which are existing in the nature, you cannot protect them. That is, what the section says. So yeah. Unless and until you modify or you make a new derivative, then it cannot. Then it can be patentable. But if it is as it is, how it is existing in nature, you cannot protect a patent for something which is already exists.
Yeah, Bhageshri, you're unmuted. You can check.
Yeah. Yes. Thank you, ma'am. Hello, ma'am.
Yeah.
My question is, ma'am, actually, I have published one paper, and in that paper, the structure and the method is already mentioned. Yeah. So that paper will be prior art, or should I means?
In India, it will become a prior art, but okay. In some countries like US, you have the 1 year grace period. So you can still go in for filing within the 1 year of your publication. Okay. But in India, it will become a prior art. Like that, different countries have different grace period. In Europe, I suppose it should be 6 months, but I'll have to check on that. But in US, I'm sure it is 1 year. So you still have a chance to go ahead and file a patent within this 1 year because you yourself have published it.
Yeah.
But in India, you cannot. It will qualify as a prior art.
Okay, thank you so much.
Yeah, there's a question from Rambha from our team. Could you please elaborate briefly on how to go ahead with conducting FTO based on different TRLs?
Different TRLs, yeah. So there are different TRLs in what we have come across, like, we have done a lot of mission projects where the objective is you have to come out with a product which you can market it, or which will have some quality for which you will have to market it. So at that time, if suppose you already know that the product or the existing features of the product are known, you are only improving its functions, then at that time, you can start your FTO at a very initial phase to figure out that what are the patents already existing in that technological area or for that product, so that you have a checklist at the beginning itself that these are the product patents. For example, in the COVID situation, everybody were working on antivirals. We know that many of these antivirals, including remdesivir or favipiravir, all these were well protected by the product patents. So if you want to reuse it or make a new formulation for the COVID virus, or you want to make a new derivative, you have to check how broad these NCEs are already protected. So you have to make a checklist of this. Okay, I have this patent where all these R groups are already protected. Can I now invent around? That would be a good start for you so that you are not wasting a lot of your time and money for reinventing the same. So you have a starting point. You know that I am going to work on it to improve its function. So what is the scope which is already protected and how I can modify it. So that is the basic level. And of course, then after you finish your lab scale, I think, I don't know what would be the exact TRL number. At least we have 1 to 3. So you can do a check there, because at the lab scale, you have all the parameters. Then we have done when like in NCL itself, we had a couple of pilot scale projects which was inaugurated when the minister had come. So we had done the FTO check before the pilot scale plant was set up. That is very crucial. So that is 1 TRL level, I think. So these 3 at least is a must before you launch your product.
Let's take one last question from Bessie. Bessie, you can unmute yourself.
Thank you, Mukta. My question is, suppose if I have only an idea, so in that case, how to do FTO?
Idea means at least you will have to put it down on paper to say, yeah, I'm starting with this material, I have this process, or this would be my apparatus with these components. You will have to put it down on paper, because unless and until you have the idea, at least in the form of an abstract or the points or the diagram, then you can't do a search. Na? So you need, for searching, we need the technical information. So that is why, yeah, we have many times our clients say, "Come, aaj mujhe ye idea mila hai," but they have to, sometimes they write it on the board when they come to us. So that is always feasible for us to do the search. But if you don't have the technical details, then how will we to perform a search, even a general search? Because sometimes you will not have a patent, you will not have this. You also have to see whether the products is already what you are imagining. Is it already existing? Many times it happens. So
Okay, ma'am, suppose if we have identified the features of that idea.
Yes.
So with that features, we can proceed for an FTO, right?
Yes, yes. If you have the features in the form of what material you are using, is this a catalyst? Catalyst, we have a fair idea. I'm going to use a biocatalyst, or is it going to be a metal catalyst? Metal means which metal? Transition metal, D block hai, S block hai. So that is what you have a fair idea. I'm going to at least use a metal-based catalyst or totally an organic complex. You have that idea, you can begin with.
Okay, thank you, ma'am.
Yeah, Kiran, you can quickly unmute. We'll just take this last one before we can close.
Okay. Hi, ma'am. I'm Kiran. Actually, just I have one doubt. That is something like there is a microbial repository. It is completely different. Microbes will be reposited, actually MTCC or ATCC.
Yes.
So here in this case, actually, if I want to utilize some microorganisms, which I already in a lab, some kind of work has been done actually from the MTCC culture.
Okay.
That same culture, just can I go taking it into the commercial level? So
is that microorganism, have you genetically modified it? Have
no,
you
no, there is no modification, genetical modification.
Is it naturally occurring?
Yes, ma'am. It is naturally already has been deposited by someone else. Actually, the study has been done in some other laboratory to some extent. The same thing, can I take it and I can able to go for a commercial purpose?
I think here, because it is existing naturally, if it was patent protected, it could be only on the process of isolating it, because you have not genetically modified it. So if you are using using that microorganism on a larger scale, isolating it by the same process which was patent protected, then you can't do it. But if you are using a new method, then of course, I think if it is not patent protected, you can use it, because it is something which is naturally occurring.
Okay. In the similar way, just I have one other thing. Actually, if it is something like there is organisms coming as an gut microbes, something like probiotics, which is in the capsule form, they are coming actually. They are actually patent protected for the.
The formulation would be patent protected in that case. I don't think so. The microbes will be patent protected.
Okay, exactly. So this capsules already it is in the market. So if I take this capsule, actually the organism, can I use it for the metabolite? Something like, and they have been, it is probiotic, just for the gut health, they have been provided. Can I utilize this?
For a different application, right?
It is for a different application.
Yes.
Is it possible?
Yes, I don't think so. There should be an issue because the microbes or they per se are not protected. So I don't think so. And if you have to make it for a new use, naturally you have to make it in a new form. Which could be a dietary supplement or this, naturally your formulation will become different.
So if it is something like, and someone claims something like, and where from you got this organism, the source. So how to claim that in that case?
Pardon?
If somebody claims me something like a commercial application I'm going at. So if somebody claims me something like, and where is the source you got this means organism. So
No,
if I say
for the patent filing requirement, as far as I know, you have to only provide the details of the source because you're using a microorganism. So
yes,
you have to provide the details from where you have got it. That is a part of the requirement for the patentability. But
so,
as far as the FTO is considered, you will not have any issue.
So, okay. So during the process, actually, if I am using it in the fermentation and the final product, whatever metabolite I am getting, that will be patented. This organism, just I will be mentioning the organism which I am using.
Yes,
so at that case,
because you're getting the metabolite from that, right? Yes.
So can I say something like from the commercial purpose means already the capsule is the source which I have been taken? Is it valid source?
No, but you will have to see whether that capsule per se, you are not taking the microorganism from the capsule, right?
Yes, in the capsule itself it is available.
Okay, you are taking it from the capsule.
Capsule itself.
Then if the capsule is patent protected, you can't use that as a source.
Okay.
Because they might have brought it into a form which is sustainable, at least till you take that capsule, right?
Okay.
So if you're taking it from the capsule as a source which is already commercially available and protected by a patent, you can't do that. But if you are going to the original source where these microbes are available, that you can take it and have a new application on that.
Okay. Even for the, different application also I can't take that same microbe.
No.
Okay. Okay, got it. Thank you.
Because they have made it. Now the formulation is something what they have invented.
Okay, thank you.
Okay, I think we should stop. We have spilled over by almost 10 minutes. So thank you, Sivakami, for this really wonderful and interactive session. Thank you everyone for participating. Please do give your feedback on the link provided in the chat box. And we will stop for today. We meet now on 10th of Jan for our 9th session in the series. And have a very happy year-end celebrations, all of you. Happy festivities to everyone. And thank you, Sivakami, once again.
Thank you, ma'am. And thank you, Venture Center Director, also for giving me this opportunity.
Most welcome. Yeah, happy to have hosted you. Okay, bye, everyone. See you on 10th of Jan.